I've been waiting 324 days for my payout from QT funded. Instead, I was sent an NDA. For the past 10 months, this dispute has been making its way through the UK courts, but just a few days ago, everything changed. QT filed a defense that genuinely surprised me, and it's something that could affect any funded trader within their firm. So in this video, I'm not going to tell you what happened, I'm going to show you. Before any of this happened, I was a max allocated trader with QT. I had $400,000 in funded accounts, another $200,000 in phase 2, and another $200K in phase 1. Now that might sound a bit excessive, but it's actually pretty normal for me to have backup accounts here and there, just in case an account is lost for whatever reason. The point is, I was in a comfortable funding situation with QT, which is exactly why what happened next was so difficult. I'd made $5,381 in profit. I requested this payout on the 25th of August, 2025. Now, it wasn't a huge amount of money, by no means life-changing, just another routine withdrawal, or at least that's what I thought. Little did I know that payout would remain pending for almost an entire year. Over the next few days, I heard nothing about my payout request. At first, I didn't think much of it. Delayed payouts weren't exactly unusual with QT. This was the same firm that had taken 42 days to return my 200K funded account during what they called a migration. But eventually, I chased it up and I received a message. Before my payout could be processed, I needed to complete a risk interview. At that point, I was convinced they were going to find some way to invalidate the payout that I knew was completely clean. Ironically, considering everything that's happened since, I actually wish that's what they tried to do. About a week later, the call finally took place, and I wasn't just speaking to anybody. I was speaking to Matthew, QT's head of risk. After a very brief conversation, Matthew told me that QT would no longer be offering their services to me. I was told that my funded accounts were being closed, that I would no longer be eligible to trade with any future companies within the QT group. There was no allegation of a rule breach, no accusation of any kind, just that my trading didn't align with the company. Now, this was strange. Just a few months prior, QT emailed me about joining what they called their flagship program, talking about A-booking and framing it, at least to my understanding, as an exclusive opportunity for a small number of funded traders. It doesn't make much sense to offer that to a trader who doesn't align with your company. Funnily enough, that proposal I'm referring to involved replacing my 400K funded accounts with phase 1 evaluations. Anyways, the call came to an end. Matthew told me that despite revoking my accounts, my payout would still be honored. He said QT would refund half of the account fees along with it. All I needed to do was sign one final contract, and everything we processed that same day. The call ended and I was sat in my office just trying to process what had just happened. I mean, any funded trader knows exactly how it feels to lose an account. That's what I was going through. Now remember, that's not because I broke a rule or because I blew an account. It was happening simply because the firm had decided. So I accepted it. It wasn't ideal, but I'd take the payout, I'd take the refund, and then tell anyone who would listen exactly what had happened. And honestly, that was the only thing that made me feel slightly better about the entire situation. So that was my plan. That was until the final contract arrived in my email. It was a non-disclosure agreement. If I signed it, I was agreeing not to speak publicly about QT, about my experiences with them, or the way this entire situation unfolded. I viewed it bluntly as they were trying to shut me up. And this is where things quickly escalated. One read through the NDA and I remember thinking there is absolutely no chance I'm signing that. At the time, my understanding was simple. Either I signed it or I didn't get paid. That didn't make a difference to me. And I get that might sound completely irrational, but it is the truth. Not because I was on some moral crusade, doing it for the trading community to expose QT. No, I barely even have social media and I don't know anybody in the trading community. My reason for not wanting to sign was much simpler. I really disliked them. And I really valued those accounts. So if I was also now going to lose my ability to speak, I had a price. And that price wasn't actively being met. So as things stood, I wanted to speak about them publicly and honestly more than I wanted what was on the table at that moment in time, which was about $7,000. Right or wrong, that's where my head was at. That was at least until everything changed. I decided to dig out the original contract I'd signed with QT. I have a law degree and contract law was actually my favorite module. So I thought I'd read through it carefully before making any decision. Well, I'm read through and I realized QT might not actually have the legal footing to make the offer they were making in the first place. And that our trading contracts actually protect us more than I thought. This section right here in simple English, it's saying two very important things. Number one, the trader will be paid according to the payout terms. So in my case, the 80% profit split. Number two, the payout will then be reviewed by the risk department. Notice how it says will be paid and not may be paid or could be paid. Do you also notice how nowhere in this entire contract does it say they can make my payout conditional when signing a future NDA? It's like me paying you £50 to fix my garden fence. When you finish, I now owe you that £50. I can't say I'm refusing to pay you the £50 unless you also mow the lawn too. Things don't work that way. I traded, I made profit, I then passed the risk review with Matthew. So at that point, the payout wasn't a goodwill gesture like they were framing it to be. According to my reading of their own contract, the payout was now contractually owed. And when I pointed this out to QT, things got nasty. I took all of this back to Matthew and made my position very, very clear. I wasn't refusing to sign an NDA on principle, I was refusing to sign that NDA for that amount, and I had my reasons. You can see from the messages I was also trying to reach out to Alex, who is the co-founder of QT. This wasn't the first time I'd directly gone to Alex when something serious had happened. The last time we managed to resolve it privately, and I was hoping we'd do the same thing here and avoid this whole problem together. This time, however, he didn't respond. I didn't know whether he agreed with what was happening or whether he'd simply not seen my message. So I tried one last time, but now through the QT live chat. Any agent I got put through to, I just asked for Alex. Instead, I was put through to Head of Operations, Fez. And this is where the dispute really begins to take shape. Now you can pause the video and read this conversation in full if you like, but for now there's two things I want you to focus on. First, why QT said they weren't paying me. Over and over and over again, the answer was exactly the same. Your payout will not be released unless you sign the NDA. Your payout is contingent on you signing the agreement. Nothing about breaking a rule, nothing about compliance, nothing about trading whatsoever. Which is interesting considering the phrase QT loves to repeat so often in their Discord and social media platforms. Follow the rules and get paid. Well, here I was, I followed the rules, and 324 days later, I've still not been paid. Second, every legal argument Fez relied on. The termination clause, the terms and conditions, that payouts were simply part of a service QT could withdraw at any time, that I had no legal precedent, basically implying you can't win here, nobody wins here. Remember every single one of those arguments, because when QT eventually filed their defense, every single one of those disappeared. Instead, they relied on something far more shocking. So at this point, I was already thinking about court. If this dispute ever ended up before a judge, I needed one thing in writing, and that was QT confirming my payout had actually passed risk and compliance, which if you recall, is a requirement from the contract. Who better to confirm something like that than head of risk himself, Matthew? So I went back to him and I lied. I told him I was considering the NDA, making out Fez had almost convinced me. In reality, I just wanted him to confirm whether my payout had passed risk. And his reply couldn't really have been any clearer. Armed with everything I gathered, I sent a formal email to Fez. 3 points, simply put. Number one, I explained why the payout had already become due under the trader contract. Number two, I said keep the refund, just pay me what is owed. Number three, if you want the NDA, compensate me fairly for it. QT rejected basically my entire email. So they were actively choosing to pay more money than I was actually asking for. Now think about that just for a second. Why would any reasonable business do that? Unless, like me, they believed the 3K refund wasn't a goodwill gesture at all. That was actually what made the NDA binding in the first place. And if you're curious why that is, just read the email I sent because I detail it there. Either way, their position didn't change. The NDA was sent again, my payout remained withheld. So within a matter of hours, I filed my claim in the UK courts and QT had a couple of weeks to formally respond and then file their defense. The process took months, but eventually the court ordered us to mediation. We attended and it lasted about 15 minutes before it was over. Nothing had been resolved, the case just continued on. By this point, I'd also applied to amend my claim, make a change to it. I wasn't just claiming the withheld payout anymore, I was also claiming damages on top. And after a few more filings here and there, the court eventually listed the case for a preliminary hearing, which was set just a few weeks ago. This isn't the final trial, it's simply where the judge gets to understand the case a bit better and then decide how it should proceed. Because I spend most of my time living outside the UK now, attending in person wasn't practical. So I asked the judge to determine the hearing based on the written submissions. So I filed mine, QT filed theirs, and this is where I was truly shocked. Okay, think back to everything QT told me. No payout unless you sign the NDA. The termination clause, the terms and conditions, that had no legal precedent. That was their position, repeatedly. So naturally, I expected their submission to explain why those arguments were legally correct. and why they were entitled to withhold my payout. Their submission didn't do any of that, and I could not believe it. Not one of those reasons were in the document for the judge to read. Instead, almost their entire submission pivoted onto something completely different. Corporate structure. QT's position was that I'd sued the wrong company. They said the contracting party wasn't Contractual Ltd, which is the UK entity. It was Contractual LLC, the St. Vincent and Grenadines entity, the Caribbean entity. To explain why that genuinely surprised me, imagine I punch you in the face and you sue me. For months, I keep telling you I had every right to punch you. And then we finally get to court, and instead of defending what I've been saying the entire time, I suddenly argue, actually, you've sued Chris. My name is Christos. That's unbelievable. It's unbelievable. In my view alone, this is them hiding behind corporate structuring so they don't need to justify their actions to a judge. And that's why I said at the beginning of this video that this affects every single QT trader. To me, and I imagine to many other traders, if you asked where QT was based, we'd all say the UK. Its headquarters are in the UK. Its job adverts are in the UK. Its staff openly say we're a UK-based firm. But the moment you attempt to enforce contractual rights through the UK, the English courts, the same English courts QT will rely on to enforce their NDA, they turn around and say, sorry, the UK company just handles some admin stuff. At the time of recording this video, I'm still waiting to hear back from the court following the preliminary hearing, but I remain confident that I'm going to win overall. Now, I can't speak on whether they've done this sort of thing to anybody else. Maybe they have, and I'm just the one person who hated them enough to turn down the money and spend the next 12 months silently pursuing them. I don't know. But I do know it's almost been a year since me and QT last spoke. So QT, Alex, James, Fez, if you believe I've misrepresented anything in this video, respond. Make your own video, explain your side, explain why my payout still hasn't been paid 324 days later. Don't do it for me, do it for your traders that still believe in you. Give them the specifics. If I'm the bad guy, say so. Because everything in this video is backed by documents that I've shared on screen. And if you do somehow win this case through an entity argument, I'm just going to drag you back to court with fresh proceedings. Only this time I'll name every QT entity I believe is responsible so the court can deal with the dispute on its actual merits. And that is assuming you're still in business by then. Which I say because in the making of this video, Prop Firm Match emailed me to say they recently delisted you, citing your financial situation and the status of pending payouts. Traders, make of that what you will. Thank you everyone for watching. Let me know in the comments any experiences you've had with QT. Very interested to know. Catch you in the next one.